The major one that we are going to consider now would be the Convention on Biological Diversity. And this was in the year 1992. But as a matter of fact, even before this Convention on Biological Diversity, CBD for short, there have been efforts in conserving and protecting life and life forms. Like, for example, in the year 1980, a strategy was worked out at the international level called the World Conservation Strategy. Three major conservation goals were envisaged: maintenance of ecological processes, preservation of genetic diversity, sustainable use of species, and ecosystem was part of this particular plan of action. But it was only a plan of action, no law yet. But then, under the Law of the Sea Convention in 1981, there has been reference to certain ecosystems, the coastal ecosystem and the marine ecosystem, which are very rich in life and life forms. Their protection, their maintenance and management became a major concern under this law as well. But it is relegated to a bit of a marginal reference that these need have to be conserved and protected, and means and mechanisms need have to be evolved at the local, national, and at the international level. That's where exactly the Law of the Sea Convention dealt with this. But then, in very specific terms, on ecosystems, which are home for certain very endemic varieties or varieties of plants and animals which are peculiar and unique to that particular ecosystem, only to be found there and nowhere else. These are very rare species of plants and animals. These are some of those which need have to have greater degree of protection, because if they're lost in that place, it will be lost forever for humanity. And so conserving them and protecting the ecosystem in which they live became a matter of major concern. And in the year 1973, an international legal arrangement called as Convention on International Trade on Endangered Species was evolved. We will reflect on that later in the next module when we deal with the wildlife law, but it was by and large about protection through prohibitions, penal sanctions for violations, and restrictions and regulations over protection of certain species and ecosystems which are very rare plants and animals. Then there was this 1980 convention called the Heritage Convention, which wanted to protect the cultural heritages which are human constructed heritage sites like the Taj Mahal as we know of, and also natural heritages like the giant coral reefs, which are unique ecosystem of incomparable value and have to be treated as heritage of humanity for all times to come, and to protect that. And so legal designs were evolved at the international level through this Heritage Convention in 1980. There is this Antarctic Treaty of protecting the Antarctic ecosystem, and the Whaling Convention of protecting one particular species of an animal variety, the biggest animal, the whale. And then there has been a treaty which is a regional convention on protecting polar bears. And then there has been this arrangement in 1971 of protecting wetlands all over the world of international significance, because wetlands are the ones which are the places of breeding, nurturing life and life forms, and protecting them. You're actually going to ensure a kind of an insurance cover against the loss of species and of plant and animal varieties. And support mechanism for that was provided through that called as the Ramsar Convention. But if you actually look to that, these are piecemeal efforts. In fact, there was one more piecemeal effort after the Convention on Biological Diversity of 1992, and that was with regard to the growing threat of desertification. Deserts were expanding the world over, and the need to confine their existence so that life and life forms would flourish. An international arrangement was worked out in 1994 called as the Convention to Combat Desertification. So these are many of the measures, as I was mentioning, peaceful measures. piecemeal measures because they deal with certain aspects of conservation. They deal with certain kinds of threats, but not every kind of a threat, not every kind of a conservation, not every kind of a management of bioresources and the knowledge associated with them, in relation to which we had huge concerns which were narrated a little while back. And so there was no single multilateral environmental arrangement, MEA for short, that encapsulated all the aspects of conservation, protection, sustainable use, safety, security, and equity in commerce concerning biodiversity. And so, in the year 1992, in the Rio Summit, the Rio de Janeiro Summit of Environment and Development, a very important convention was crafted. Over 180 state parties became parties to this particular arrangement. In terms of significance, along with the United Nations Framework Convention on Climate Change of 1992, which was the subject matter of our discussion in the fifth module, this is another international arrangement which has the largest subscription of membership for an international treaty outside the United Nations Charter. And so, very important international arrangement, much more than any other international arrangement. This has the largest number of members of nations, community of nations, which are members of this, and so it is of international dimension, of such reach, very similar to United Nations or that of climate change. What does it incorporate? This convention on biological diversity has the following principles. The first major principle is to conserve, the principle of conservation. Conservation actually means conservation of life, protection of life, upkeep, maintenance, management, ensuring quality and integrity of a particular resource, both ex situ and in situ. In situ means within the habitat, wherever it is found, which is ideal for its existence, it's called as the habitat of that particular resource, like our own home, which is the best place for us to live. Like that, every plant and animal variety have their own home, which is called as the habitat, natural habitat. And conserving them in their natural habitat is the primary concern. And there are times when you cannot conserve them in situ, mainly because of a variety of reasons. And one reason is it may be because of floods, or it may be because of certain other natural calamities like earthquake or anything. Then keeping them in their natural habitat would be dangerous. It may even lead to their extinction. So under those circumstances, or there is a widespread disease, as a result of which this particular species would get lost. And so what do? You take it in a place which is other than its natural habitat, simulate a condition similar to that of its natural habitat, a laboratory condition. We call it as a glass house or a greenhouse, and in those you nurture them. It's called as ex situ conservation. So this law incorporates the principle of conservation, and second, recognizes and reiterates the sovereign right of nations. When once you say a nation is a sovereign nation, it actually means that it has complete authority, control over every resource that is there within its territory. And every resource includes every biological resource. The flora, the fauna, the plants and animal life, they all come within its territory and over which the state has the complete right over that. And this law recognizes that right. Yes. So if anybody wants to access this, they have to have your leave, license, and permission. And the state has the power to exercise its rights and to ensure the protection of its own interests. And this is what has been provided under this law. This law insists on observance of the principle of precaution to ensure the safety, security, and integrity of the particular resource and the knowledges. This is especially with regard to the application of science and technology and the various processes of development. Well, a particular species of a plant and animal may be lost if we put them into certain kinds of experimentation of changing its very complexion, of changing its very characteristic feature through biotechnological processes or anything like that. And in that event, the risks that are involved, you need to really put it into scientific temper to see that the changes that come about, if they can be reversed, or if there are other species available, other varieties of that available, which can be stored and conserved in its original form, then to allow it to carry on. And the kind of safeguard measures that you need to have is a matter of concern in law. And so, to provide that kind of a word of caution, the application of the principle of precaution, provision has been made under this. The other objective is that biodiversity cannot be conserved, cannot be protected, the sovereign rights of nations cannot be protected unless and until all nations come together as a cooperative venture. This is a common property. And the resource, if you are going to lose, it may happen to us also the next time when somebody else may commit piracy of that against our own interest. And so we needed to cooperate that anyone who is indulging in it, we will share information, we will share technology, we will work together in order to ensure that this piracy is eliminated and we share knowledges associated with that so that the resources are conserved, protected, and put to best use amongst all of us. So, this law envisages an international legal frame of prescriptions, and with those basic frame, the details have to be worked out at the national level. And so, with this frame, with this outline, that each and every country which is a party to this arrangement needed to work out at the domestic level the details, the nuts and bolts aspects of working this law so as to ensure the resources are conserved, the resources are put to sustainable use, they are safe, no piracy, and there is equity in ensuring the benefits derivable from that are shared fairly and justly. So, this is a law that prescribes the strategy of contractual arrangements that I, as a sovereign state, I enter into a contractual arrangement with anyone who wants to access my resources for commercial purposes. And it's in the form of a standard form of agreement, which clearly prescribes do's and don'ts. When you access it, how you can access it, when you can access it, in what form you can access it, what purpose you are going to access it, and how you are going to put that to different kinds of uses, all put in a contractual form. And this requires observance of all the principles of contract law. That means when somebody wants to access it, he must come clean, put all his cards on the table as to why you are accessing this resource and what kind of use that you are going to put into, of what quantity and at what rate you are making an offer, and for which the host country or the one who is going to enter into an arrangement with you is going to give his acceptance by giving an informed consent. And this informed consent should be free from bias, should be free from coercion or duress, should be free from undue influence, should be free from deceit or fraud, should be free from mistake. And any of these vitiating factors, if they exist, it becomes an illegal arrangement. And so all the elements of a contract are worked out here. The state will prescribe the norms whereby you can enter into an arrangement. How do you share the benefits derived? Element of transparency and fairness in all commercial dealings is part and parcel of this arrangement. In specific terms, if you look to the specific provisions under this law, it provides for sovereign rights and responsibilities. In the slide, you will be able to find out what is the reference provisions of that. So, you can appropriately refer to them. As to what are the sovereign rights, that you can lay down conditions of access, you can prescribe the manner of access, you can lay down a particular fee for access, you can lay down a particular arrangement whereby the benefits could be shared. The responsibility of the nation is to ensure that the one who has an arrangement will have access in accordance with the regulations, and then the source from where it could be accessed is made very clear, and the rights of those who are going to be affected by this are protected. And it's also a responsibility that if somebody is going to put this particular resource in application elsewhere and tries to get an intellectual property right over that, the sovereign nation, on behalf of this particular country, on behalf of those traditional right holders, would be able to argue in an international forum to reclaim that particular right because it is a sovereign right of a state. So that's the kind of rights and responsibilities prescribed. This is one first major international legal arrangement which provides for protection of traditional knowledges and communitarian practices associated with that. There is a clear provision for that under this convention, which clearly says that recognition, making provision for protection, acknowledgement, and sharing of benefits of putting those knowledges and resources into application to the communities of people, the holders, the transmitters, the carriers, and those who are responsible for nurturing these resources and knowledges is something which is part of this law. It calls for the cooperation amongst nations in science and technology, in facilitating access, in providing assistance, in accessing and putting this to various kinds of uses to ensure sustainable use, in ensuring biosafe use and application and things like that, and for which it also provides for financial mechanisms wherein the United Nations Environment Programme, the Global Environment Facility, and the World Bank would put together an arrangement whereby the technological assistance and the financial assistance is made available for those countries which are in need of that to conserve, to protect, to maintain, to manage, to improve the quality, to ensure biosafety, to promote technology of access, management, and improving the different varieties of plants and animal varieties. Handling of biotechnology and sharing of benefits is an important provision under this law. And the working out the nuts and bolts of aspects of it are put in the hands of the conference of parties. Conference of parties is from among the parties, a small group is envisaged, which would be continuously be meeting to work out the details of each of these elements of this particular framework law. And then they come up with additional legal arrangements, which are referred to as protocols, to work it out. And in terms of administrative arrangement and settlement of claims and rights, it does not provide for an international mechanism. What it provides for is, once again, a clarion call for cooperation amongst nations. If there are disputes, if there are any conflicts amongst you, you need to find ways and means of mechanism of getting into negotiation and settle between and amongst you in an amicable way through negotiations, through conciliation, by making use of the good offices of people who are going to act as umpires, and through a process of arbitration. By any of these means, you sort out the differences rather than a centralized international control. It is a decentralized one whereby states have not only the right of control over the resources, they also have a duty to cooperate with each other to resolve any conflicts and iron out the differences amongst themselves. This is a framework law. The reinforcement of this law is done through two major international legal arrangements which are referred to as the protocols. One on biosafety and another on equity. The biosafety arrangement is what is referred to as the Cartagena Protocol of 2000, and the equity arrangement the details of which are worked out in another international legal arrangement called as the Nagoya Protocol on Access and Benefit Sharing Mechanisms in the year 2010. That is the subject matter of our inquiry and discourse in the next session.